Hello everyone, welcome to the channel Learn Law with Professor Rashmi. Today we are going to talk about one of the important principles in environment law, that is precautionary principle. Before going to discussing the precautionary principle, if you are really liking the videos, please do subscribe to the channel because it is absolutely free for you, but it does make a lot of difference to me. Also share, like and comment the video lectures. Coming forward to precautionary principle. Before precautionary principle came into force, that is before 1972, assimilative capacity concept was into operation. What is assimilative capacity? It meant that environment is going to assimilate whatever pollution we are going to cause. It will absorb the shock of pollution, but after a certain limit, when pollution won't be absorbed by the environment, then when we see the damage, at that time efforts can be taken to repair it. So role of law would only begin after such limit is crossed or such damage is caused because of the pollution. But what used to happen in this assimilative capacity concept, that law would come into force or into action only after a damage is caused to environment. So after Stockholm Conference, this concept was discarded and precautionary principle came into existence. What does precautionary principle simply means? That it is prevention is better than cure. We generally say that. So law will come into action even before the irreversible damage is caused, because once a damage is caused to the environment, bringing the environment to its original stage is difficult. At times it is also impossible. So it's better to avoid such activities that which would cause any irreversible damage, and therefore law should come into action or come into force even before such damage is anticipated. Important case laws. First, most important case laws is Wello Citizen Welfare Forum versus Union of India 1996. In polluter pays principles also, which we discussed earlier, you have seen that Supreme Court said that polluter pays is an essential feature. Same, likewise, in Wello Citizen Welfare Forum versus Union of India 1996, Supreme Court held that precautionary principle is an essential feature of sustainable development. Supreme Court also supplied the meaning to polluter pays in meaning to precautionary principle in context of municipal law. So Supreme Court said that environmental measures are to be taken by state government and statutory authorities by anticipating any environmental damage, by preventing and attacking such activity which is going to cause environmental degradation. So it is a duty upon state government and statutory authorities to see that precautionary principle is applied, to see that any activity which is proposed to be done is going to cause environmental degradation. So it must anticipate any such degradation, prevent and attack such activity. Also, it was held, the second thing was under precautionary principle was held by the Supreme Court, that when there is a threat that serious damage or irreversible damage may be caused to environment, such activity should be immediately stopped. Here, there is no scientific proof or certainty required to prove that such activity is going to cause irreversible damage. Even if there is an reasonable apprehension that such irreversible damage is going to be caused, then there is no need of any scientific proof to prove that this activity is going to cause environmental damage. So such activity can be stopped without even producing any such scientific proof. Supreme Court further held that onus of the proof, if it is needed, should be or would be on the actor or developer or industrialist who is proposing such activity. So it would be responsibility of an actor or developer of industrialist to prove that the action which he is going to take is environmentally benign, or his action is not going to cause any environmental damage or serious irreversible damage. So onus of the proof would be always on the person who wants to undertake the activity and not on the other person who is just apprehending that such damage would be caused. This is the beauty, or you can say speciality or unique feature of precautionary principle. In this case, Supreme Court relied upon the report of International Law Commission, which suggested that precautionary principle should come into place where there is an identifiable risk of serious irreversible harm, like extinction of species, widespread of toxic pollution, major threats to essential ecological processes, and it is appropriate to place burden of proof on person or entity who is proposing the activity that such activity won't be harmful to the environment. Supreme Court further in this case declared that precautionary principle has been accepted as part of the law of land. Moving further, next important case is MC Mehta versus Union of India 1997. It is also popularly known as Taj trapezium case. In this case, expert studies proved that the emissions which are made by the industries who are using coke or coal as its fuel are producing such pollutants in Taj trapezium zone that they are damaging the environment, and effects are seen on the Taj Mahal, that is yellowing of Taj Mahal is taking place. So Supreme Court held that the industries which are identified by the Pollution Control Board as potential polluters should change over to natural gas as their fuel, industrial fuel, and those industries who are not able to obtain the gas connections as the industrial fuel to be used is natural gas, the industries which are not in position to obtain gas connections should stop functioning in Taj trapezium zone. So henceforward no industry shall use coke or coal as the industrial fuel while functioning in Taj trapezium zone. Next case law, AP Pollution Control Board versus Professor M.V. Naidu, AIR 1999. This is also one of the important case law with respect to air pollution. Here Supreme Court observed that principle of precaution involves the anticipation of environment harm and taking measures to avoid it or to choose the least environmentally harmful activity. So basically either to avoid the activity totally, or if that activity is necessary to be carried out, to be done, or such way should be chosen that least effect on environment is caused. So environment is least affected. Precautionary duties must not only be triggered by suspicion of concrete danger but also by justified concern or the risk potential. This is what Supreme Court held in AP Pollution Control Board. Now, where is this principle of precaution applied? You will see that precautionary principle is applied in environment impact assessment. Environment impact assessment is basically weighing the impact of a particular project or particular activity on environment, its pros and cons, and then to discuss whether this project or activity is environmentally viable. This is all about environment impact assessment. So this is derived, or precautionary principle forms the base of EIA. So always remember that offshoot or base of precautionary principle is environmental impact assessment. So this was all about the precautionary principle which I had to share with you. We will meet in next environmental law lecture very soon. But please do subscribe to the channel, share, like and comment, and also let me know the specific topics on environmental law which you would like to have the video lecture on. We'll meet you soon. Till then, bye. Thank you.